Right, hello again. Welcome, one and all. We've got Paula here. Hello, Paula. How are you?
I'm good. Hello, Peter. Hello, everyone.
So we're going to try and explain this complicated thing about evictions at the moment. And trust me, it's complicated. We got confused, didn't we, Paula, talking about this before
We
starting
did.
recording. It's
We've
taken us,
unpicked it now.
it's taken us 40 minutes to sort it out before we can even tell you. So it's really, really complicated. Do you just want to quickly introduce yourself and say where you're from?
Yeah, my name's Paula and I'm a solicitor. I'm from Woodstock Property Law. We've been going about 5 years now. I've been practicing in landlord and tenant law forever, it seems. And there's a lot of challenges at the moment. So hopefully we will be able to help you.
Indeed. Thank you very much. And this is certainly one of them. And just to explain, there is a fact sheet on this on our website. So do have a look at that. Email us at info@ihowz.uk if you're unsure, because it's complicated. Trust me, it's complicated. So evictions. Let's just take the easy one first of all, Paula. I've got a tenant, and as at today, they suddenly get themselves 2 months in arrears. So forget past history. They're 2 months in arrears as at today. What should I do? That's a simple one.
Okay, let's keep it really simple. I like that. That works. So keeping it very simple, if you came to me and said, look, I don't know what to do. My tenant's in 2 months arrears, help. First of all, I would say try and work with the tenant to agree an instalment plan. So if it's circumstances and the tenant's, been furloughed or struggling a little bit, it's better to work with the tenant at the moment than go down the court process. If the tenant is saying, I can't afford the rent anymore, I'd like to hand the property back, I would strongly advise that you come to an agreement, and that can be incorporated within a deed of surrender, which I understand there's a template available, or it will be available.
There is.
So try and settle first. If all of that fails and you've exhausted those options, the next step is to serve a possession notice. Now, if there's 2 months arrears, historically, you could give 14 days notice on a Section 8 notice, which is the notice that you use when there are rent arrears. At the moment, you have to give 6 months notice, which is a long time, especially if you then have to go to court. So it's 6 months notice. If you're at the end of the tenancy or towards the end and you can serve a Section 21 notice, so that's the no fault notice, you should do that, because that's also 6 months at the moment. But it means if it then has to go to court, the judge has to grant a possession order as long as it's valid. Whereas with a Section 8 notice, if the tenant reduces the arrears, the court doesn't have to, which might be fine, and you may be happy to keep the tenant. But this is usually when you've exhausted all options and you just need your property back.
And the first phase of complication is, you mentioned it's a 6 month notice with a couple of months arrears, but when it gets up to 6 months arrears, then the notice period changes, doesn't it?
That's correct. So the notice period then goes to 4 weeks. So, and you can serve 2 notices. So when you're serving, you get a little bit tongue-tied on this, but you can rely on another, 2 Section 8 notices. So if the arrears do creep up and it works out better to then reserve it and give 4 weeks notice, that's what we advise you to do.
Yep. Okay. Right. Next slight complication. August the 3rd is a very, very important date. I served notice after August the 3rd. What happens then?
Okay, so you've served the notice, it's expired.
Yep.
The tenant's still there.
3 months then, wasn't it?
Pardon?
It was a 3 month notice then, wasn't it? On August.
Yes.
Yep.
Yeah, 3 months then.
Yep.
So the notice has expired.
Yep.
You need to go to court. So
Yep.
we're preparing court proceedings. So let's say the Section 8 notice has expired.
Yep.
We want to complete, I don't know if you use the online system, so PICO,
Yep.
possession claims online, or you can do a paper application. You're supposed to, and you were supposed to do this before, but the rules have reconfirmed it. You're meant to supply a rent schedule up to 2 years. So make sure you do that.
Yep.
So once you've issued the claims, you've filled in all the paperwork, that's gone off to court. What we're finding at the moment with the possession claims online is that the courts are almost using it as a reminder tick list and providing you with a date. Now check with the court what that date means, because it doesn't necessarily mean it's a hearing date, and it also doesn't mean it's a review appointment, which I will explain what that means. It seems to be a date that the courts use to list the hearing, not actually list it, but to look at the file. So just ring up the court. If you have a date and it's unclear, make sure you check. Now it's important to check, because with Section 8 claims, there's something now called a review appointment. And at this review appointment, what is happening is the judge is reviewing the paperwork. So you will receive notification of a review appointment, and then 14 days before that, at least 14 days before that, you have to send the court and the tenant a bundle of documents. If you do not do that, the case could be thrown out. So make sure that happens. Now, the bundle of documents include the court papers, a witness statement. So we put something simple together, just explaining what's happening. You know, the tenant entered into a tenancy and Section 8 notice was served on this date. Here's a certificate of service, and here's an up-to-date rent schedule. And also you should attach what's called a knowledge notice, and the government have templates of you know, to help you. Make sure you provide them with the correct information. Now, the knowledge notice was set out any knowledge that you have as to the pandemic impacting the tenant or the tenant's dependents. So you can put all that information into the knowledge notice, collect all the other documents and serve it on the court and the tenant. Then what will happen is the court will review all the documents, and what we're seeing is list it for a hearing. So what is meant to happen is this is an opportunity not only for the judge to review the paperwork, but for the tenant to take advice and to call the landlord or their lawyer to try and settle the claim. Every single case that we've had through with a review appointment, no tenant has called, neither has the judge. So we've had nothing. So what is then happening is a hearing is being listed. So whether it's a hurdle just to delay the case, I don't know. But it's important you get the paperwork correct. Otherwise, you may have a judge that's very unhappy. We have had a case where the judge didn't get our paperwork. We emailed it to them. They acknowledged receipt of it. They made a mistake. And what they have done is they've relisted it for another day. So they didn't say your case has been thrown out or you have to make an application. They've acknowledged their mistake and resolved it. And that is happening a lot. So the courts are doing their best. You can imagine how busy they are at the moment, a huge backlog, all these bits of legislation that are coming out left, right and centre. We've got to give them some slack. So always make it easy for them as well. Explain in your letter why you're providing the documents to them, what's included within the bundle, that you want it to go on the court file and ready, you know, in preparation for the review appointment, say the date, make sure you put the claim number. So make it really easy for them because it's less likely to go wrong. So that's with Section 8 claims at the moment. If we were issuing on a Section 21 and we were going the accelerated route, we would serve the paperwork as normal. And I'm sure you've updated the form now, the new accelerated form, which you practically have to attach a tree to it.
Including all the gas certificates.
So every single gas certificate, all the how to rent guides, EPC, all the tenancy agreements. So you'll need everything. If you've lost a tenancy agreement or there's something missing, but you're confident it's been served, you can do a paper application like an N5 and an N119. You might want to take legal advice, but don't panic. If documents are missing, there's a possibility to go another route. But if you want to use the accelerated process, everything should be attached. And also what should be attached to that is a knowledge notice. So similar.
Right. Now, next complicated step, if the notice was served between March the 23rd and August the 3rd, you have to do it, don't you?
Yes. So we've got something called reactivation notices. So at the moment, if the claim's been stayed, and you've got until the end of January, so don't panic, to serve what's called a reactivation notice. And again, there is a template on the government website which makes it really easy. You're meant to confirm within that notice if the tenant or their dependents have been impacted by the coronavirus. You're supposed to attach a schedule of arrears. You file that at court and you file it on the tenant. File it on the tenant first. That's what the form says. Make sure you say how it was served. There's a little box there and it's easy to miss, but it says who have you served it on, and I think it says the method of service. Complete that. If you don't complete it, it'll be sent back to you. And then what will happen is the court will list it for a review appointment, or the file will go to the judge if it's an accelerated claim to then review the paperwork and hopefully grant a possession order.
Okay, right. It's all been easy up to now, isn't it? Now
I know. Am I making it sound easy? I'm trying to simplify it.
Now the complicated one. We had an amendment to the law last week, which basically said if you had substantial rent arrears. So explain that one, if you don't mind.
Of course. So the relevant date is the 23rd of March. So if you have a possession order, whether it's granted before the 23rd of March or after, as long as you've got at least 9 months arrears before the 23rd of March, the judge should allow the eviction to proceed between the 11th of December and the 11th of January.
Yeah.
So it's the 9 months arrears is the key point here. And those arrears have to accrue before the 23rd of March, 2020.
Yeah.
So if you have 6 months before then and 3 months after, and then you're granted a possession order, there won't be an eviction between those dates.
Yeah.
The 11th of December and the 11th of January. However, as we are now finding in practice, because we've recently had a case on this, when we've applied for an eviction, the courts have actually said to us, you need to make a formal application.
Yeah.
So it's not as simple as just saying, look, here's a rent schedule. There were at least 9 months arrears before the 23rd of March. Please schedule a bailiff appointment.
Yep.
That isn't going to happen. You have to do an N244. Then it will be listed for a hearing.
Yep.
And then it will go to the bailiffs to list an eviction date. So I think, and this is a good feeling or a bad feeling, that you're not going to get any evictions during that period because the courts aren't going to have time to list it.
Yeah.
So the reality is, unless it's something exceptional, so the other exception was antisocial behaviour. So if you've got an incredibly difficult tenant who's causing hell, then I can't see the judge prioritising it. And even in that situation, we've had cases, it has been very challenging to get it listed quickly. Nothing is happening quickly, nothing.
No, well, antisocial behaviour has always been a difficult one, isn't it? Particularly getting proof.
Yeah, and proof is really difficult. I've got a case on at the moment, and I'm working with the council because the council have a lot of powers. Yeah. So they're looking at a closure order, which can only be for 3 months, but they're also looking at injunctions. And it's easier for them to get an injunction to basically compelling the tenant to behave, right, or not to go near the property. So they have a lot of power. So we are issuing court proceedings based on antisocial behaviour. Yeah, it's a flat. There's other occupiers who are going insane because he's partying all night. Yep. And the council are taking action. That doesn't mean you don't need a possession order, because even when the council shut the property down, that doesn't terminate a tenancy. So we are still carrying on down that road, but we're trying to help the residents. But yeah, so, you know, that's an example where it's still taking time. Okay. It's been going on for months.
I think this is a good example that, you know, if you've got problems with a tenant at the moment, try and resolve it directly with them. Always get proof. We always say to landlords, always keep proof, just in case you end up in court. Most of the time you don't, but just in case you end up in court, you always need that proof. But at the moment, ask. Make sure you ask. Yeah,
communicate. It's a big thing. Communication is key. So, you know, we're writing to tenants and saying, look, have you been impacted by the coronavirus? In respect to that, people may be wondering how the courts will then deal with that information. Yeah. The answer is, we don't know. We haven't had any Section 8 claims listed yet because of the pandemic. Right. Accelerated claims, they are granting possession orders.
Okay.
I can only think that a judge will allow up to 42 days.
42.
Yeah, that's the maximum they are allowed to grant with a possession order.
Right.
But who knows, we're in a pandemic.
And the point being, I mean, some landlords could end up with up to 2 years arrears, couldn't they?
They could. It's quite scary.
Yeah.
So that's why I'm saying to landlords, look, it's okay, it's not sophisticated advice.
Yeah.
But cut your losses. If a tenant's saying, here's the keys.
Yeah.
You know, can I take take the property back?
Yeah.
Yes, take the property back.
I agree. And most landlords are of the attitude, first priority is to get the property back legally, because you mentioned a deed of surrender. We've got one on the website. So everything we've just been talking about, look in the document section 1A. Everything's there. All these court forms are there as well. So have a look through that. But make sure you can prove satisfactorily that they have handed the keys back, just in case they turn around 2 months later and say, no, I didn't hand the keys back.
Yes.
Which can
I mean, a surrender, it's always worth remembering with a surrender.
Yeah.
It's better to have it in writing. But if I'm the landlord and I'm saying, I want the property back, and the tenant is saying, I want to hand you the property back, that's a surrender.
Yep.
So, and make sure you do a good checkout, photographs,
Yes.
The usual safety nets.
Okay, well, Paula, thank you so much for all of that, because it's complicated.
It is.
That at the outset when we started discussing it between ourselves. It took us 40 minutes to sort it out before we could even start recording. So
we got there.
Complicated. So thank you so much for that, and look forward to seeing you the next time.
Brilliant, absolute pleasure. Thank you.
Okay.